Hello, my students, and welcome to Commercial Law. Today we are going to virtually discuss the topic of accessions and commingled goods. Somewhat related, but treated differently. So the analysis and my explanation of it will treat them separately. So what are we talking about when we're getting into accession or commingled goods? An accession is when you have one item and then you add another item to it, another good. Classic example of that is automobile tires. One company, probably the dealership, would have a security interest in the automobile as a whole, which is, of course, as we know, perfected by an indication on the certificate of title. And then there is the sale of tires to the owner later on, and they're very fancy tires, very expensive tires, and so the retailer that sells the tires takes a purchase money security interest in those tires, and then those tires are installed on the automobile. And then the owner of the automobile goes bankrupt and defaults on both obligations, both to the dealership and to the retailer who sold the tires. And so what happens? This sets up the contest. The dealership wants to claim that they have a security interest in the collateral as a whole, the automobile as a whole, including the tires. And of course, the retailer wants to be able to enforce its purchase money security interest and remove the tires from the automobile. Okay, and that sets up the contest. Is the retailer able to do that? Now, it's a good example, but it's also it's a special example. And we'll see when we look at 9.335, and that's where we'll find all of the rules collected with respect to accessions. And 336, right after, it deals with commingled goods. Yeah, in 9.335, it's section D that deals with the special question of certificate of title goods, such as an automobile. So keep that in mind. Let's consider another example of an accession that doesn't involve a certificate of title goods. Well, let's think of my telescope right back here. Right back there, that's my telescope. It's not particularly expensive, not a particularly fancy one. It's good for looking at the moon. But let's say it were particularly expensive and I purchased it. This is a top-of-the-line telescope. It cost me $20,000. And after I purchased it, which I purchased on credit because I didn't have that kind of money in my pocket, I wanted to get a special celestial tracker, which can scan and recognize where we are in the universe, and it helps me point the telescope. But that was also very expensive. It cost me $5,000. But you see it mounted there. You see it mounted right there on my telescope. Now, that's an accession, you could argue. And if I default on my obligations to both the seller of the telescope and the seller of the celestial tracker, then the seller of the telescope might claim that it owns the telescope as a whole, including anything that has become part of that telescope, any later accession. And the seller of the celestial tracker will say, hey, I have a purchase money security interest in that celestial tracker, so I defeat any other security interest, give it back to me. So that's how the contest would line up. How is it resolved? Well, I think one thing, and let's look now, let's turn to the statute itself, which is right here. 335A. A security interest may be created in an accession and continues in collateral that becomes an accession. Okay, that's a preliminary rule. Now, what does this mean? This means that if you have a security interest in something, in an item, and it becomes an accession, that is, it's added to another good, such as the celestial tracker added to my telescope, then the original security interest in that celestial tracker, it will continue in the celestial tracker, even though it's been united with the telescope. So the original security interest continues after the accession takes place. That's the first rule that we're going to learn. But before we go any further, let's look at the definition of accession, which is not in 335, but is back in 9102. Accessions, the very first definition. It means goods that are physically united with other goods in such a manner that the identity of the original goods is not lost. And this distinguishes accessions from commingled goods, on the one hand. I want to point that out. Because in commingled goods, the identity of the original goods are lost, such as when you break eggs and mix them with flour and make a cake. You can't pick out the eggs and flour anymore and disassemble it. It's lost, and you've created a new mass, a new good. But with the accessions, not so. You add the celestial tracker to my telescope, and you can still see it. You can still take it off. But some might see that it's become part of the telescope. If you make that argument that it's become part of the telescope, then you are in the world of accessions. Then you have to turn to 335 and figure out who has the best claim to it. The secured party with a security interest in the telescope, or is it the secured party with a security interest in the celestial tracker? And you go to 335. But if you are the lawyer for the retailer who sold the celestial tracker, you'll try another argument, a preliminary argument, to get to defeat the telescope retailer right off the bat. And what is that argument? It's a preliminary argument that we don't even go to 335 because the celestial tracker has not become an accession. It's not become part of the telescope. I could walk right up to it right now, and with just a quick flip of a little tab, just slide it right off of my telescope. It's not part of the telescope. It's just something you can put on it and take off it very easily. But it's a celestial tracker. Telescope here, celestial tracker here. Just because I put it on the telescope doesn't mean it's become part of the telescope. It has quite its own identity, Your Honor. And if you make that distinction, if you make that argument, and the argument is largely based on how easy is it to replace it. Is it meant to be a permanent part of the other item, or is it meant to just be temporarily there and removed and back and forth? And if it's temporary and not intended to become a permanent part, and it's easily removable, you can argue that it's not an accession, and therefore it hasn't become part of the telescope at all, and therefore the telescope retailer has zero interest in the celestial tracker. It only has an interest in the telescope, and it can only claim to have an interest in the celestial tracker if they are successful in arguing that the celestial tracker has become part of the telescope. But, Your Honor, it has not. So that's one argument that you could make, just to deprive the competing retailer of any claim whatsoever, because their claim is only in the telescope. And if the celestial tracker doesn't become part of it, they have no leg to stand on. So that's a first argument that can be made. That's not evident really in the code, but you can see how it is legally justifiable. So, let us go back. 335. Let's look at a few more of the provisions. I was trying to explain to you how it all works, but you got to actually know the code, how it pieces it together. So A explained to us that, yes, a security interest in a good that's added to another good, a security interest will continue in it, but only if it's an accession. If a security interest is perfected, when the collateral becomes an accession, the security interest remains perfected in the collateral. That is, if I, as the Celestial Tracker retailer, have a security interest when I sold the Celestial Tracker to Professor Sundahl, and I immediately, well, I didn't file a financing statement because automatic perfection. So I have a perfected security interest when it is then added to the telescope, and my security interest will continue in the tracker even though it's become part of the telescope, if that's how the judge rules. And I will have a perfected security interest in that celestial tracker because it was perfected before it became part of the telescope. Okay, back to the code. D. No, C. Except as provided in D, the other provisions of this part determine the priority of a security interest in an accession. And that means when you're trying to determine priority, you just look at the regular rules that we know. There are no special rules for accessions. But there are. It says here first that aren't, that the other provisions of this part determine priority of security interest in an accession. But then you go to D, and it does provide a special rule. And this rule gives super priority to the secured party with the perfected security interest in the certificate of title goods as a whole. That is, the dealer with a security interest in the automobile will always defeat another secured party with a security interest in the accessions, such as the tires. So they get that super priority. And that just gives, well, it's obviously a great benefit for auto companies, and improves their bottom line and their financial security, and that is passed along to the customer in the form of low interest rates on the credit sale. So with that, let's turn to the problem. And let's see, what is the best way to get to this problem? This is it. Yep. Okay. And we have only one problem in the book about this issue, accessions. It's 109. I just had it up here, but I will find it. Accessions and commingling. Okay. Problem 109. So, when Jane Witherspoon filed her bankruptcy petition, she was living in a manufactured home that was in no way attached to the realty on which it sat. Okay. This harkens back to our assignment on fixtures. Was this a fixture? Is it not a fixture? Is it so attached to the realty as to become part of the real estate? I don't think so. It doesn't sound like it. It's not attached in any way. It sounds like it can roll right off there. And so probably not a fixture. Anyway, that was just a little bit of review. Let's go back here. Anyway, poor Jane has gone bankrupt. And in the bankruptcy proceeding, LifeMaster Financing Company claimed a security interest in the home and all accessions pursuant to a security agreement. So obviously she had borrowed money from LifeMaster Financing Company and granted them security interest in this mobile home and all accessions. The accessions were not separately listed in the security agreement, but LifeMaster argued that they included a porch that Jane had installed, as well as storm windows, a heater, carpeting, built-in dishwasher, a replacement bathtub, refrigerator stove, one air conditioner unit for the bedroom window, smoke detectors, and drapes. Which of these items, in your opinion, are accessions and which are not? And now the question here, let's try to approach it as we do all of our priority type questions where we're seeking to determine who has the best claim to the collateral. Who are the claimants, and what is the collateral? So we have here Life Master Financing Company. They've got a security interest in this home. Okay, so we have Life Master as a secured party with a security interest in the mobile home, which will be a certificate of title form of collateral. Okay, so it's not clear whether they perfected the security interest. We can talk about whether or not that matters. But it has a security interest in the mobile home and all the accessions. Now, so it wants to seize all of these. Just take it all. Let's take the mobile home with everything in it, all the things that are listed here, including the porch. So who is the other claimant? It's going to be the bank trustee in bankruptcy, who, as I've explained before, is always trying to place this protective blanket over the assets of the bankrupt entity. It's a protective stay over all attempts by other parties to seize the assets. So that's the other competing claimant, is the trustee in bankruptcy, who's trying to stop them from stop the finance company from seizing the mobile home and all the goods. But if it has a perfected security interest, we know that you defeat the trustee in bankruptcy, because the trustee in bankruptcy is a lien creditor. And if you're a perfected secured party, you defeat the lien creditor, as long as you're perfected before a lien creditor arises, which is true in this case if they had the security interest noted on their certificate of title. So that's one question, and we don't have enough facts to determine what the case is. But that only applies if the goods in question are accessions. If they are accessions, then we look at 335. Now, we know that the general rule is that the perfected secured party will have priority over a lien creditor, such as a trustee in bankruptcy. So that is the typical rule, and it applies with respect to accessions, that the perfected secured party is going to defeat a lien creditor. And so it's perfectly clear, and you don't even need that super priority rule, which is cited here, 335D. You don't even need it, because that's super priority is for a secured party who has a security interest in the automobile, or here the mobile home as a whole, when they are facing defeat at the hands of a purchase money secured party. That's when this rule D steps in and says, no, the owner's security interest in the certificate of title, good as a whole, will always win. We'll always defeat another secured party. But we don't even need that, because we're not up against another secured party. We are up against a lien creditor, the trustee in bankruptcy. So we're going to win. Under that analysis, always. The only way that the trustee in bankruptcy can hope to get any of these items, they'll certainly lose the mobile home. They're just trying to protect some of the items at least, get the washer, dryer, etc., the heater. Maybe they can salvage something and not let everything go to this credit company. And so what is their argument? That these things are not accessions. We go back to that preliminary argument where we kind of started this discussion. And I did bring up, let's see if I can find it. Yes, here it's from a case that cites the Edie case that is mentioned, cited in this problem. I thought I'd bring it up as it helps us learn this rule about how do you determine whether something is or is not an accession. So I'll read through it here. An accession under Article 9 is generally thought of as a good that has become integrated with the principal property such that it cannot be detached without causing injury and has little independent utility if removed. Okay, and this is another analysis that can be used. But as I mentioned before, there's also the intent analysis, or is this intended to be a permanent part of the principle when it's added to it? The difficulty of removal, which is what injury refers to. Let's go back. So examples of accessions include porches, and this is the list that we have here in the problem. So porches, storm windows, metal skirting around a manufactured home, heating appliances, carpeting, fireplaces, bathroom fixtures, and built-in dishwashers. Okay, so we can look back at our problem and see if that covers everything. Porch, storm windows, heater, carpeting, built-in dishwasher. I guess not if it's not built in. If it's not built in, then it's not an accession because it's more easily removable and can cause less damage. It's not intended to be permanent. Bathtub, refrigerator, stove, an air conditioning unit for the bedroom window. I don't know, an air conditioning unit for the bedroom window. I understand central heating, appliances, but if it's more easily removable, like a window unit, there's a stronger argument that it's not an accession, and the trustee can protect it from the finance company's grasp. Smoke detectors and drapes. Again, I think there are arguments. Probably the easiest argument is drapes can be removed easily. You know, they don't cause any damage, and it makes sense that people might have a favorite set of drapes, and maybe it's their grandmother's drapes, who knows, that they always intended to keep with them and never wanted them to be permanent. They would always travel wherever they went. You could make arguments like that. And same with smoke detectors, although smoke detectors typically
key detectors and drapes.
Oh my goodness.
Which of these items, in your opinion, are accessions and which are not?
Stop. Okay. I should use that in class. The smoke detectors. I think it's maybe a little more difficult because smoke detectors are typically intended to be a permanent part of the structure, and they may be wired in. A lot of them are wired in now and difficult to remove, would cause destruction. On the other side, you could argue they could just pop them off if they're that type, and pop them in your bag and go off to your next apartment, pop into your next apartment. I suppose that argument could be made, but I don't really like it. Okay, so let's end our discussion of accessions and talk about commingling. Unlike accessions, commingling is when you have two sets of goods that, yes, are combined, but the identity of the separate goods are lost when they are combined. They're no longer identifiable individually. They form a new whole. And an example of that is cake. And that's an example that is detailed in multiple examples in the official comments to 9336. That's not the only example. Another example, but it's also similar, just different materials, is, let's say, the creation of an alloy. Let's say you're making the ancient alloy electrum, which is a mixture of gold and silver. And you have one partner in this venture that brings the gold and the other one that brings the silver. and each of them have bankers that have a security interest in their gold and silver, and they invested in their venture and smelt it and melt it and combine it into this alloy, and then they all go bankrupt, and these two banks now both want to seize this nugget, whatever it is. Imagine a big nugget or a nice bar of electrum. But who gets what? How do you divide that electrum up? Is this 50-50? What's the rule going to be? And the rule is set out in 9.336. So let's take a look at it. We can say goodbye to the textbook for now. Bring up Cornell, their fabulous UCC site. I only wish they had the comments on it, but apparently there's some legal reason, copyright reason why they don't. I'm not sure, but it's really too bad. I'm surprised they can't figure that out, but it probably costs something, and they don't want to pay. Can't pay. I know they're trying to raise money. Okay. Here we go. Right. Priority. Nope, that's not the right one. We went back. We need to go forward. Okay. There we are. Now we're going in the right direction. I was wondering why it didn't look right. There we go. Commingled goods. All right. In this section, now we have the definition of commingled goods right here. We don't have to go anywhere to find it. In this section, commingled goods means goods that are physically united with other goods in such a manner that their identity is lost in a product or a mass. So, this may be a threshold question that you could face, as it might be more beneficial if you are treated as an accession as opposed to commingled good. And so you might have situations where it's difficult to, there might be arguments on both sides. For example, let's say instead of melting, gold and silver, let's say you just created gold and silver flakes, millions of them, and then mix them together in a wonderful blend of gold and silver flakes. But the flakes are tiny. They're like little grains of sand. Now, theoretically, you could, with the help of a microscope and many people over many hours, sift through every one of these little grains of gold and silver and show that their original identity is intact. But that seems absurd. I think at that point, what you have is a commingled good, where you can no longer separate it out. It is what it is now, this mixture, this blend of gold and silver flakes. I guess you could make the argument of that something is an accession rather than commingled good in every case if you go down to the molecular level. I had a security interest in the eggs, and the proteins in those eggs, while you may not be able to see them, they are in this frosted cake. The proteins have precisely the same molecular makeup as they did before, and if you get an electron microscope, and we have at it, we could carve out all the molecules that were originally subject to the security interest in eggs versus flour. Okay, so, clever lawyers can always find a way, but at some point it doesn't pass the smell test, right? It becomes ludicrous. So that would obviously be ludicrous, but you see what I'm getting at. Let's go back to the code. Commingled goods. So what happens with commingled goods is the opposite of what happens with accessions. With accessions, remember the security interest in the accession continues when that item is added to the good, affixed to the good. But with commingled goods, the original security interests are extinguished. The security interest does not exist in commingled goods as such. Now, this maybe isn't the best way written, but it means that you can't have a security interest in the original goods once they become commingled goods. So you can't have them in the commingled goods. Like you have an original security interest in the eggs, and after they're baked, you can't have a security interest in the eggs anymore as after it's become commingled, now that it's a commingled good. So any security interest that existed before commingling is extinguished. You no longer have a security interest in the eggs. No one has a security interest in the flour. Instead, the security interest attaches to the cake, to the commingled good as a whole, this new good. A security interest says it can be. A security interest may attach to a product or mass that results when goods become commingled goods. So it says we can. And here is really the operative rule. If the original collateral becomes a commingled good, a security interest attaches to the product or mass, the commingled product. So it is the original security interest in the eggs or the flour. Once they're mixed together, blended a little so that they're no longer distinguishable. The security interest in the eggs and the flour goes away, it's extinguished, and in its place immediately springs up a security interest for both parties in the cake. So now they're sharing collateral. We'll see how this turns out. Okay. If a security interest in collateral is perfected, this is the first of our priority rules. If a security interest in collateral is perfected before the collateral becomes commingled, the security interest attaches to the product or mass under the security interest that attaches to the product or mass is perfected. And so what does this mean? It's not the priority rule, I'm sorry. It's the perfection rule that you not only get this new security interest in the cake as a whole, but if you had a perfected security interest in the eggs, you'll have a perfected security interest in the cake automatically. If you didn't, then you won't be perfected in the cake. Okay, now I think we'll get to priority rules. Yes, priority of the security interest. Except as otherwise provided, subsection F, the other provisions of this part determine the priority of a security interest that attaches to the product or mass under subsection C. Okay, well that's very familiar. That's exactly the general rule we got with respect to accessions. So that's good to know. So for example, if you have one party with security interest in the eggs and another party with security interest in the flour, and the security interest in the eggs was perfected and the other one in the flour was unperfected, they get commingled. They both have a security interest in the cake, but one of them has a perfected security interest. The person that had a security interest in the eggs that was perfected. Now they have a perfected security interest in the cake and the other party does not. And we know the general rule there that a perfected party will always defeat an unperfected secured party. So that's one scenario. If there are other scenarios, though, and there are many of them, and I recommend looking if you want to strengthen your understanding of this rule and study. When you study for the exam, it's worthwhile to look at the examples because they do lay out various examples using the egg and the cake and the flour, and it's really quite illuminating, even if it's a little bit banal. But sometimes, simple examples are the best. But imagine other scenarios where you do have a perfected security interest in both the flour and the eggs, and now you have to have these parties go against each other, two perfected secured parties. Let's continue reading because as you probably noticed, there's an exception to this rule or some further elaboration on it. So here we go. A conflicting security interest. If more than one security interest attaches to the product or mass under subsection C, following rules determine priority. Okay. All right. A security interest that is perfected under subsection D has a priority over a security interest that is unperfected. Okay. Well, we arrived at that just through the general rules, but okay, it's making it clear here that if you're perfected, you defeat the unperfected security interest. Good. Now, if more than one security interest is perfected under subsection D, the security interest rank equally in proportion to the value of the collateral at the time it became commingled goods. Now, this is a special rule. It's not the first to file or perfect, which typically decides priority among contesting perfected secured parties. I think I got that straight. It's not the first to file or perfect rule. Now they're just going to, regardless, as long as you're perfected when the commingled good was made and you have a perfected security interest in the commingled good, and now there's bankruptcy and you're both diving in for as big a piece of the cake as possible, this is how it's resolved. That it's not winner take all, as most priority contests are. Instead, we're going to divide this cake. And how are we going to do it? According to the comparative value of the ingredients that were donated by the two parties. So we'll see some examples of that. It includes a little bit of math, but I have some examples here. Yes. Actually, we can do, I guess, yeah, the problem, example number 5. Looking at the, if you follow along with me, looking at example number 5 and comment 6 to 336. We're getting into the eggs. So here we have SP1A. So we have this one secured party. Has a perfected first priority security interest in eggs, the debtor's eggs. Okay. SP1B has a perfected second priority security interest in the same collateral. Okay. Well, it's making it a little more complicated, but it'll all come together. Now we have 2 secured parties. With, I wonder if I have a, okay. I was looking for something to write on the screen. I thought maybe I had a pen like that, but we will visualize intellectually. We have 2 secured parties, 2 banks, let's say, that have a security interest in all of the eggs. One of them has priority, was the first to perfect. The second one is a second priority. Okay. Very good. And the eggs have a value of $300. Okay. Debtor owes $200 to SP1A and $200 to SP1B. Okay. $200 to each of them. Got it. On $300 worth of eggs. That is called under collateralization. You'd prefer to be over collateralized always. And most deals provide for that. Now, SP2 has a perfected security interest in debtor's flour, okay, which has a value of $500 and secures a debt of $600. So again, under collateralized. Debtor uses the flour and eggs to make cakes, which have a value of $1,000. Okay. Now we're going to figure out how to do this. What is the situation? Well, we know that whoever was perfected before the commingling will have a perfected security interest after the commingling. So we have one bank that's perfected security interest in the cake through the eggs, and one that has an unperfected security interest in the cake through the eggs. And then we have the other party would have a security interest in the flour. That party now has a perfected security interest in the cake. So we have two secured parties with a perfected security interest in the cake, one with an unperfected security interest in the cake, and then keep in mind that two of the secured parties have a security interest in the same collateral, the eggs. Let's see how all of this turns out. For purposes of subsection F2, SP1A and SP1B should be treated like a single secured party. Okay. The collective security interest would rank equally with that of SP2. Okay. So it's looking at this rule now, F2, that if more than one security interest is perfected under subsection D, the security interests rank equally in proportion to the value of the collateral at the time it became commingled goods. Okay, so and let me just correct one statement I just said. I was saying that the one secured party, the bank that has security interest in the eggs, was unperfected. Not true. They were perfected, right? Both parties were perfected, just one was perfected first, filed first, and therefore has first priority, and the other secured party just had a second priority, but still a perfected security interest. So now, all of these secured parties, the two egg secured parties, the flour secured party, they all have a perfected secured party in the cake. Okay, now we've got that straight. Now what do we do? And the first step that this that the commentator here says is that, first off, the first step is that we're going to treat the secured parties with a security interest in the same collateral as one secured party. We are going to, for the first step of the analysis, we're going to group them together. So that means that we have the secured parties, the egg secured parties, and we have the flour secured party. And we combine them with respect to the value of the eggs in which they have a security interest. As you're really looking, what you're looking for is you want to know the value of the eggs as a whole and the value of the flour as a whole. And then you're going to compare those, and that is going to tell us how to divide up the cake between the two types of secured parties based on the collateral. All right, this is getting a little complicated, but I am happy to tell you that I have drafted a one-page concise summary of all of the rules regarding accession and commingling. So I will be sure to send that out to you, and it should, I think, clarify things nicely. But of course, we can discuss in class. Anyway, to get back to the analysis, this is the first part of the analysis. We're going to just look at the value of the eggs as a whole and the value of the flour as a whole and compare the two. And the value of the eggs as a whole were what? $400, I believe, $300, right? And the value of the flour as a whole was $500. So what does that mean? We have $300, we have $500, $800 total in the value of the ingredients. 3/8 of that came from the eggs. 5/8 of that came from the flour. That's how we are going to divide the cake. 3/8 of this $1,000 cake go to the egg secured parties. 5/8 of that cake go to the flour secured party. Now, the flour secured party at that point is taken care of. So with the secured party and the flour out of the picture for a moment, now let's turn to the secured parties with the security interest in the eggs. Now they get 3/8 of the cake, and of course they're going to sell this cake for $1,000. They're going to get 3/8 of that $1,000, which is $375. Okay, so now the question is how to divide up that $375 between the two of them. Well, we know the priority is going to be the first to file or perfect, which was the first secured party, which had an outstanding obligation of $200 that the debtor owed him, and so that party will be able to collect the $200. You can only enforce the security interest or priority to the extent that you have an outstanding obligation. So that party will be able to recover $200. Anything left over will now go to the junior secured party, which was what, $175 left over. It doesn't quite cover that second secured party's outstanding obligation. He's still owed $25. Is there any hope for him to reclaim that last $25? Well, let's move back to the secured party with security interest in the flower. How much did they get? $375 went to the Eggmen. $625 therefore goes to the flower man. That's right. Yeah, $625. But what was the obligation owed to the flower man? I think it was $500, if I recall properly. Value of flyer, the value had $500 of the flower, but secured $600. So that party has priority with respect to $625, but can only collect the $600 that it's owed. That leaves $25 left, and that will go to the other secured party. Okay, they're all secured parties in the cake. We divide it up this way, first by the collateral, right, the egg portion and the flower portion, and then we determine priority among the secured parties with respect to the particular collateral, according to the general priority rules. But if there's anything left over after this equitable division is made, then it's going to go to any of these secured parties that hasn't been paid. You know, the one party, first Eggman secured party, was paid off, so he's out of the picture. He's all set. The flower party got its $600 debt paid off. There's $25 left, and the only person that is still seeking and still chasing this collateral, this cake, is the one secured party, one egg secured party, and it's still owed $25, and now he will finally have first priority with respect to that $25 portion of the cake because the other competing claimants are gone. Okay, so that wraps up our lesson on accession and commingling. It is a little complicated, so don't expect to feel like you've mastered it in a minute. But please look at the handout that I'm going to send you because I think it does a pretty good job of highlighting the important rules and gives some structure as to how you should go about analyzing these problems. So I hope that's helpful. We can, of course, discuss it further in class, but I will see you then.